All right. Now, can the landowner simply refuse to exercise either of the options under Article 448? He does not want to appropriate the building. Sabi niya, ayaw ko niyang building mo. Anong gagawin ko? Ang pangit niyang bahay mo. Okay? Neither does he want to sell the land occupied by the building. Ayaw ko ding ibenta. In short, he simply tells the builder, lumayas ka. Tanggalin mo yung building mo dyan. Dahil hindi mo lupa yan, lupa ko yan. Can the landowner do that? The answer is, he cannot. He cannot. He cannot just refuse to exercise his option and simply ask for the removal of what in good faith has been built or planted on his land. Okay. The options are limited to those in Article 448. Okay. But supposing that the landowner avails or elects the option of selling his land. O sige, bilhin mo na lang yan. Ito ang presyo. And the value of the land, let's assume further, is not considerably more than that of the building. The builder, however, is unable to pay. Wala. Kahit na sunugin mo yung builder, wala kang maaamoy na pera. Wala siyang pera. Pambayad doon sa land. Sabi ng Supreme Court, if that is the case, then the landowner can ask for the removal of the building. If having opted to sell his land, and assuming the value is not considerably more than that of the building, the builder is unable to pay, then that's a situation when the landowner can actually ask for the removal of the property, of the building. Okay. Any other remedies available to the landowner if that were the case? The builder is unable to pay. Okay. Of course, there is always the remedy of simply entering into a lease. Okay? They can simply enter into a lease. Sige, hindi ko pala kayang bayaran. Sige, lease na lang tayo. Okay? And there is a third remedy. So they can enter into a lease. Number two, the landowner can ask for removal. And third option, the landowner can ask for the sale of both the land and the building. The proceeds of the sale will be first applied to the value of the land. The rest, kung anong matira, any excess will be delivered to the owner of the house or the building. Prior to the time, okay, that the landowner exercises his option of either appropriation or sale, prior to that, prior to his moment of decision, the builder would of course have been occupying the land of the landowner. Can he be required to pay rent for his occupancy during that period prior to the exercise by the landowner of his option? The answer is yes. He should be. Okay. The moment the landowner, however, exercises the option to appropriate, there arises the right of retention on the part of the builder. From that moment, he cannot be compelled to pay rent. Okay. If the landowner opts instead of appropriation, ang option niya is sale of the land to the builder, can rent be demanded in the meantime? The answer is yes, of course. Yes. Rent will have to be paid until such time when the property, when the land is in fact acquired by the builder. Pag na-acquire na yun, of course, he's the owner already, he simply does not have to pay rent anymore. Okay? Next point. We said earlier that these rules on accession on a movable property would not apply to a situation where it is the landowner himself who builds or plants on his property. Diba? Kasi sabi natin under the law, planted, built, sown on the land of another. Kung sarili mong lupa, no application to. Now, having said that, it follows therefore that if a co-owner of property builds or plants on the property under co-ownership, these rules would not apply. Not. Because a co-owner is the owner of an ideal aliquot share of the whole. And as a matter of fact, under the law on co-ownership, a co-owner has the right to use the property under co-ownership, as long as he does not prevent the other co-owners from similarly using it. So, if something is built or planted by a co-owner, these rules on accession do not apply. However, if the co-ownership has already been terminated by a partition of the property, and after the partition, it is discovered that one of the co-owners, one of the previous co-owners, has built on a part of the property which was later on adjudicated to another co-owner, then the rules under Article 448 should apply. Okay? Pwede. The co-owner who had earlier built on the property under co-ownership, but a portion of whose building is discovered to encroach upon the part adjudicated in the partition to the other co-owners, will have the rights of a builder in good faith. Ha? Kung terminated na ang co-ownership at na-discover na, halimbawa, we are the two co-owners. During the existence of our co-ownership of our parcel of land, I built a building on that land. Later on, we agreed to partition the property. Tapos ang co-ownership by partition. Pagka-partition natin, na-discover yung building ko pala, a few square meters of my building occupy the part allotted to you under our partition agreement. Article 448 can be applied. Okay? I will be considered as a builder in good faith with the same rights under Article 448. Okay. The good faith, the claim of good faith, may be made by a successor in interest of the original builder. Okay? In one case, a certain land together with the building standing thereon was purchased by a buyer. Later on, upon a resurvey of the land, it was discovered that a portion of the building encroached upon the adjacent property. Ako. Sabi ng Supreme Court, yes, the buyer in this case can invoke good faith. Okay? And the provisions of Article 448 can apply. All right. it's, well, sometimes to a certain extent, it's quite amusing to remember some of the cases involved. In one case, can you imagine, there was a couple, they bought a lot from a subdivision. So, okay. Bilang lot, usually, mga subdivision, lot number so-and-so, block number so-and-so. Okay. Ito, bili. Okay. The time finally came when they decided to construct a house. So, punta sila subdivision. Tinanong nila yung the representative of the subdivision developer. Oh, we are going to construct na. Saan nga ba yung lote na nabili namin? Ito ho. Tinuro, itong lote nyo. Di okay. They constructed. Nak ng tokwa. Hindi pala yun yung lote. Nagkamali ng turo. Okay. Can they invoke the rights of a builder in good faith? Of course. They can invoke the rights of a builder in good faith. By the way, even if the property involved is registered property, halimbawa, magkatabi yung lote natin, pareho may titulo. Of course, when property is titled, very precise ang description niya ng boundaries. Beginning at the point marked 1 on plan. 2,000 meters from BLLM, etc. Ganyan. Then, north, ganon-ganon, 70 degrees, 40 minutes, whatever, 2.2, then yung boundaries niyan, precise. Can you still claim good faith if the properties are covered by a torrents title? The answer is yes. Tandaan natin ang rason, baka matanong. Because if you are an ordinary mortal, ordinary person, you are not expected, unless you happen to be an expert in the science of surveying, you are not expected to know the precise boundaries of your property, even if your property is covered by a torrents title. Kung surveyor ka, yan, okay yan. Pero tayong ordinary mortals, anong malay natin kung nasan yung mga north 70 degrees na yan? Okay? Although, of course, meron na ngayong mga GPS. GPS. Di ba? GPS, yung sa cellphone lang, meron yan eh. Sabihin sa iyo kung nasaan lugar ka. North, ganito, eksakto, up to, sabihin sa iyo, accurate to within 5 meters. Meron ng mga GPS na kinakabit sa kotse, dala-dala mo. May nagsasalita. Turn right after 100 meters. Turn left after ganyan. Meron. But even then, sabit, the rule still applies. Unless you happen to be an expert in the science of surveying, you should not be held accountable for a mistake. So, pwede pa rin good faith. Pero, ibang usapan naman kung, halimbawa, I built on a lot in Manila. Nakita kong bakanteng lote. Nagtayo ako doon. Nung sinita ako ng may-ari, sabi ko, ay, ganun ba? Pasensya, akala ko lote ko ito eh. Wala naman akong titulo maski ano. Okay? Ang pag-aari ko nasa Quezon City. Wala akong property sa Manila. Can I claim good faith? No. I should not be allowed to claim good faith. My mere assertion that I thought I had the legal right to bid on the property obviously is a vagrant assertion. Why vagrant? Because it has no visible means of support. Okay. So, hindi pwedeng vagrant assertion. Okay.